Your Honor, my name is Joseph Thomas on behalf of plaintiffs.
Colin Gatton on behalf of Lewis County and Board of County Commissioners.
And this is a motion for partial disqualification. The court has reviewed the pleadings in this matter. I'm familiar with the case. Do we need to address any procedural matters before going forward with argument?
No, Your Honor.
No.
Very well. I will limit the parties to 10 minutes per side. And you may proceed, Mr. Thomas.
Your Honor, I'll be really short. I'll save whatever time I have for rebuttal. This is just, we asked the court to make a ruling off the plain language of the statute. As this court knows, under the Open Public Meetings Act, the plain language of the statute in RCW 42.30.120 states that there shall be personal liability for the civil penalty. And plaintiffs argue that when when a government official is held personally liable, that means that they are not acting in their official capacity anymore. They're acting in their personal capacity. And it would be inappropriate for the Lewis County prosecuting attorney to represent individuals in their personal capacity, because then the Lewis County Prosecuting Attorney's Office would be acting in, engaging in private practice of law, and then also it would be using public funds for a private cause, and that violates both the state statute and the Constitution as laid out in the pleadings. And I'll reserve whatever time is left for a rebuttal. Thank you.
Thank you, Mr. Gatton.
Your Honor, the argument on the county's behalf is very simple, that we have a duty to defend when we're a real party in interest, any county official that is related to the argument, or related to the complaint. Here, the complaint focuses on changing official actions of the county commissioners in their official capacity as a governing body, as members of governing body of a public agency. Although it is the case that the plain language, well, the 42.30.120 allows for a finding of personal liability by way of a civil penalty, the court would still have to find, in order to enforce that penalty, that the member or members of a governing body of a public agency took action in violation of any provision of the OPMA, with knowledge of the fact that that was in violation of the OPMA. And so, in essence, to decide the disqualification motion today, they're asking the court to actually decide the case by making a finding that they are to be held liable under that statute, which is what's at issue, and is what is the defense, both by the county, because they want to preserve the official actions of the BOCC, and the county commissioners, who we have an interest in defending. Now, it might be the case that the court would, once the proceedings are done, find that there is a knowing violation of the OPMA. But we haven't said that the county hasn't agreed to necessarily indemnify that payment, because the court will be ordering them to pay out of their pocket. That's not what at issue. At issue is whether or not we can actually defend them. But the suit in and of itself is in an official capacity. And so we'd ask that the court deny this motion for partial disqualification.
Thank you. Mr. Thomas.
Thank you, Your Honor. I'll be brief. Mr. Gatton and Lewis County don't explain how this isn't public use for, or public funds for a private cause. He's going to be representing their personal bank accounts. The case law is pretty clear that when somebody is held in their personal capacity, that they'll be paying personally for this. And so it's going to come from their personal bank account if they're found guilty, or they're found liable for this. And this isn't something that the county's going to even pay. As the Court of Appeals has ruled in the, forgive me if I'm mispronouncing this, the Ugaster case, that it would come from the private bank account of the government officials. And just because they're government officials doesn't mean that they always have a right to representation by the government. If they're acting outside of their official capacity, then they lose that right to government representation because of the Washington Constitution, Article 11, Section 14, that states that it's prohibited to use public funds for a private cause. And then the revised Code of Washington, which also states that prosecutors in counties with a population more than 18,000 are prohibited from engaging in the private practice of law. And I don't even know what the private practice of law would be for a government official if they're not defending the personal bank account of a government official. So we just asked this court in order to partially disqualify the Lewis County Prosecuting Attorney's Office and Mr. Gatton from representing the Board of County Commissioners in their personal capacity. This is a narrowly tailored motion, and we think this is appropriate in this circumstance. Thank you.
Thank you. The court at this time is denying the motion to partially disqualify the prosecutor's office in this case. Have the parties submitted orders or agreed to orders with regard to the court's ruling?
Yeah, I have a simple order if Mr. Thomas would like to take a second to review it, and maybe we could enter that. It just notes that the motion is denied.
Please take your time, Mr. Thomas.
I think it's appropriate also.
And I sign the motion. Thank you, counsel.
Thank you, Your Honor.